Thank you, Mr. Kwan. Just one point of clarification. Indeed, I used to practice law just behind here, 100 meters behind. My office was at Hong Kong Street, but I no longer practice law. Today, my advocacy is no longer for private clients, but it's for the public good. It is. I'll do that. Sorry, I hope you can hear me now. I practice my advocacy in the court of public opinion. Thank you. Thank you, the online citizen, Marwa, CAN, and Function Aid for organizing this gathering to talk about fake news law. I'm grateful to you for the opportunity to join the other speakers in addressing our concerns about the law. You know, Singapore is a beautiful country. If you look around you, I always say this. It's an amazing city. It's something to appreciate. You have a wonderful new jewel at the airport, great malls, fantastic parks, very clean streets. But what's the point of a beautiful city if the people are oppressed? So today, my comments will be divided into two parts. Time willing, I will first talk to you about some perspectives that I have about the law. We will take a step back, take a big picture look at this, and then we might look at some features that I'm concerned about. So let's start with the perspective. The first one is this. Make no mistake, this law is a severe limitation of our freedom of speech. The freedom of speech is the mother of all human rights. It is the one that girds all other rights. Without your freedom of speech, the other rights become an illusion. Bear that perspective in mind. This law will represent perhaps the single most egregious or serious attack on our right to free speech and expression. And we cannot take this lightly. We cannot say this is business as usual. Now, the second perspective that I want to address is this. And that is that this law will literally be a most disturbing act of governmental interference in the public's right to address their concerns. In fact, may I say this, that it is my view that this law is being passed because the PAP government wants to control what you see and hear. Everybody has said this, and let me just underline what everyone has said. And that is that before 1995 and the internet, the narrative was largely defined by mainstream media. What you knew or what you understood about what was going on in Singapore was what the government told you, because the government controlled mainstream media. And basically, mainstream media has been the stalwart mouthpiece of the government. Now, this fact has meant that they didn't have to do much, because there were no alternative media. There were no alternative voices. Instead, what you had was what the government told you. 1995, things changed a little bit because you had the internet. And with the internet came social media. Now, what that meant was that you have many other alternative views being aired, and that created a problem for the government, because all of a sudden now there was noise. There was not just their voice. And this has been a big problem for the government, and they have been thinking of ways and means to control the internet, as it were, which is seems like a silly idea, but this law is exactly that. It's an attempt to take control of the narrative in so many different ways. One, by simply defining what is true and what is not. By creating fear, as Mr. Kwan suggested, that simply by suggesting that the mass media is where what you hear on the mass media is very powerful, because it suggests to you a certain idea, etc. Now, the other perspective that I want to get to is the fact that this act will do more harm than good. I think this is important. Here, let's make no bones about it. We need to be concerned about the government's ability to abuse the powers that it will get under this act. To start with, let me just say that I'm not saying that there are no falsehoods out there. I'm not saying that falsehoods are not harmful. What I am saying is that the way this act has been constructed, it gives the government too much power, and it will do more harm than good. So, I need not go too far than to say to you that we were told that in Malaysia, they decided to, the Pakatan Harapan government decided to make a promise to withdraw the act, simply because they felt that you cannot give that much power to a government. The fact is that a government is an entity that wields a lot of power. And you cannot allow so much power in one entity. Let me just say this. I will talk about trust. A lot of people have said that you have to look at trust as a measure of whether the government has done something wrong. And you look at this by looking at the results of elections. So what they're saying is, so there was a professor who says, look, if the government is guilty of abuse of power, then what you will have is you will have a price to pay. In today's paper, an editor talked about the fact that you have already given the government a lot of power, and why are you complaining about correcting a falsehood or correcting a post on Facebook? At the end of the day, the government has a lot of power. And if you're not happy, there will be a price to pay. I don't think that's the right approach. Let's look at the track record of this government and look at how they have used their discretion in the past. You have a litany of examples of overreaching, of misuse of power. Let's just take Operation Spectrum. And I see So Lang here. And that gives us one example of some concern that this government has not used its power in the correct manner. It's my opinion that there has been no proof that any of these persons did what they did or are what they say they were. Now, that being the case, if the professor and editor are correct, can anyone here tell me why the PAP keeps winning elections after elections after elections? The fact is that Singaporeans will continue to vote for the PAP even if you throw their critics or dissidents into prison. And I think that has been quite clearly the case for some time. So, this question of trust has to be looked at from the point of view of the Westminster style, parliamentary style of government and the separation of powers. The separation of powers is based and founded on a distrust of human nature, and more importantly, a distrust of the concentration of power. And that's where you get this saying that power corrupts and absolute power corrupts absolutely. And what we've given them is carte blanche to decide what's true and what's false and what's in the public interest. So, the point I'm trying to make is that while yes, we are concerned with harmful content on social media, we ought to be much more concerned with the harmful use of laws such as this one against the citizens. Now, another context and another perspective I'd like to talk about is the social perspective. What's important to understand is this, that we are talking about social media. This law will essentially be a social media law, if you like. Now, we all go to the kopitiam and we all have a nice chat. And, you know, when you have a chat in the kopitiam, do you expect to be fined or jailed for that conversation? No. Now, some of you may think that this example is far-fetched or not relevant, but I'll explain its relevance. The fact is that what's social and social media is a form of social life that's been extended online. Social means informal, casual, not serious. Social really means not work or not official. Now, if you think about that for a second, if you just think about what I've just said, why are we getting so excited and so upset about what goes on in social media? The social context is important, and that's the point I'm making. At the end of the day, you must take this context into mind when you talk about online falsehoods. Our law simply ignores that, and that's wrong. The British House of Lords, in a case they decided about a defamation matter for a post online, made this point and said that you must take into account the social context when you talk about social media posts or Facebook posts. And they say it, and they made it very plain that you cannot treat a newspaper article and a libel in a newspaper article the same way as you would treat a Facebook post. And I think that's correct. Doesn't that seem logical to you? But our law does not set that type of threshold. And that's a real pity. So, I'm suggesting that even if you had any law to deal with malicious, harmful content, that you make a distinction between the standards that you apply to social media and how you interpret social media and how you interpret a newspaper or a formal letter. And this is not the case. Now, the other perspective that I'd like you to have is with respect to the amount of authority that this law has given to the government. Now, don't take my word for it. The United Nations Special Rapporteur for Freedom of Expression and Opinion just sent a letter to our Prime Minister to suggest his concern that there is just too much authority given to the government, and that this law, as it was framed and as good as the intentions might be, is wrong. It's unacceptable. And he made that claim. So don't take my word for it. Take the United Nations Special Rapporteur, who is a law professor, and he knows a thing or two. And he said, you can't do that. Now, That brings me to the point about the government making themselves the gods of lies and falsehoods. They have literally become the arbiters of truth. On suggestions as to them becoming the ultimate arbiters of truth, there was a robust rebuttal. But I disagree for two reasons. First and foremost, the fact is that even if you draw a distinction between ministerial discretion and the exercise of judicial power, if the exercise of the minister's discretion or his decision-making ability amounts to the exercise of judicial power, and in this case it does, because you are talking about a determination about the finding of facts, about the truth and falsehood of a fact. And that is most certainly a judicial matter. Now, what's happened here is that by the government reserving for itself, at first instance, the right to make a finding of fact and to decide on the truth or falsehood of something, they are acting like judges. That's what I'm saying. Even if they say they are not, even if they say that there is oversight, judicial oversight, they are, the fact remains that they've done it. Now, second, just imagine, and the second reason I disagree with the rebuttal that no, we are not the ultimate arbiters, the courts are, is this. How many of you, how many of us will go to court for a Facebook post which you are told to take down? Do you have the money for that? Or do you have the gumption to do that? Most of you will say, okay lah, I'm just going to take it down. I mean, what a waste of my time. Even this I cannot say. And that's going to be the case for 99% of the cases. Do you see where I'm getting at? For all practical intents and purposes, I say to you here in Hong Lim Park that the government has made itself the ultimate arbiters of truth. In Singapore, they are the ultimate authority. And that's really bad. So, I now deal with another feature or part of the bill that concerns me and which is related to what I just said, and that has to do with this whole idea of the accused judging his own case. In many instances of falsehoods, I'm not saying all falsehoods, in many instances, you will find that it's a criticism about the government. Don't you think that's what this bill is about? It's about an attack on the government. Now, that being the case, will it not be that the minister will be deciding on the truth or on the public interest aspects of what you just said about him or his ministry. Now, do you see where I'm going with this? So we are talking about basically a conflict of interest. I happen to know quite a bit about the conflict of interest, for reasons I will tell you some other time. Now, what's important for you to take away today is that half the time they will be saying, he's attacking me, and that's nonsense. That is utter rubbish. Now, imagine that. Will there not be bias? And that takes me to the next point. There is an associated sort of a common sense rule, if you don't mind me calling it. And these rules apply to any adjudication and are used by many lawyers to attack tribunals who make decisions. And in many cases, this will be your minister. Now, these are rules as to natural justice and as to a fair trial. So natural justice is a general concept, and it applies here. That's what I'm suggesting to everyone here today. Now, it applies in the sense that there are two broad rules. One is that you will not be a judge in your own cause. And from what I've just described to you, do you see that they will be judges in their own cause and in breach of that rule of natural justice? And second, tell me, when somebody is attacking you, how fair can you be? And that brings me to the second rule, which is that you will give the person a fair hearing and a chance to address your decision before you make it. In our law, you will be allowed to challenge it in court in a very difficult process after the minister has made his decision. That's not the way it works. In order to arrive at a fair decision, your accuser has to give you a chance to have your piece, to say what you think of what you've just done. Now that's called a fair hearing. Now that rule is also breached. And finally, bringing back that point I made about trust and power, the doctrine of separation of powers demands that for the sake of check and balance, for the reasons I told you earlier, which is that there's this basic distrust in human nature and in power, that you separate these powers, the executive power and the judicial power. But in this case, again, you find that even this basic tenet is breached. Now, what I don't understand is why, despite everyone telling the government that this is a really bad news law, it's not a fake news law, it's a bad news law, the human rights organizations, the UN rapporteur, many of us here, my fellow speakers, various persons who have written about this, they are the only ones who seem to think that this is just fine. This is a great law and it's going to save Singapore. Well, them and their sycophant, mainstream media that will do their bidding. These are the only two people who are saying that this law is all right. It's not all right. And we are here to express our concern that it's not all right. I think I've run out of time. I have a lot more to say. I wish I had gathered my thoughts better. I thank you. Oh, really? Okay. Oh, well, apparently I have a little bit more time. Let me see whether there's something. Yeah. I think there is one other point I want to bring up. And it's a feature of the law that is missing. And this concerns me. Now, you know, everybody calls this law the malicious online falsehoods law. We've been told it's about malicious actors. We've been told that it's about people with very bad agendas. My question to everyone is this: where is the requirement for malice in the law? Now, if that was your basic premise and that was what you advertise, shouldn't you then include that threshold in the law? I say yes. Thank you. Now, I'm not being facetious here. I'm just saying that if we buy your argument, and you know, if we buy your argument, then why, oh why, have we not set into this law a higher threshold of proof? Not just the intention of committing a falsehood, but a higher threshold of malice, meaning ill will, meaning a grudge, a motive. Where is that in the law? So with that thought, I'd say to you that the only reason why they did not put that into the law is because it will be very difficult for them to prove that, because every one of their critics has the public interest in mind and is hardly a malicious character. And on that note, folks, I thank you for your attention and for coming. It's wonderful to see you. Thank you for hearing me. This is my debut speech. Bit nervous about it, but I hope I've made some sense. Thank you very much. Thank you.